Good morning. Can you hear me, Ms. Sprague?
Yes, I can.
And Mr. and Ms. Colsey, can you hear me?
Yes, Your Honor.
Okay.
Live.
Hmm?
We're live, Judge.
Okay, thank you. We are here this morning on number 2023J0241, Wells Fargo Bank as trustee versus Sarah and Benjamin Colsey. This is a review of an appeal bond and use and occupancy order. So the way we do this when we have hearings by Zoom is the appellant party, so that's you, Mr. and Ms. Colsey, will go first, and then we'll hear from Attorney Sprague. You're entitled to, I'm going to give each side 10 minutes. Generally, there's no rebuttal, but I may have questions for you again at the end of Attorney Sprague's presentation, Mr. and Ms. Colsey, or I may not. Do you want to divide the time between the two of you? Or do you want to just have one of you talk for all of it? How do you want to proceed?
If it's okay with you, Your Honor, I'm the one that has dealt with this the whole time, so I would like to be the one to do all the speaking.
That's totally fine with me. So once we begin, I am hopeful that in that box that says Massachusetts Appeals Court, a little countdown clock will appear that will tell you how many minutes you have left. When it gets to 0, it turns red, or it should turn red, and your time will be up.
Okay.
So I will, in fact, hear first from you, Ms. Colsey.
Okay, good morning, Your Honor. Thank you very much for hearing us today. I'd like to apologize first and foremost because we just received notice of this meeting today. The mail came this morning and got the notice, so kind of rushed. So I apologize if I'm not as articulate as I'd like to be. Your Honor, this case has been ongoing for a very long time. Back in 2007, I was late on 2 mortgage payments. I admit that. I've always admitted that. I mailed those mortgage payments to the then mortgage company, Option One. Option One sat on those payments for almost 2 months before they returned them to me, stating that I was in foreclosure. Ever since then, it has been an ongoing battle trying to just pay my mortgage. In 2015, Wells Fargo came in and attempted to foreclose on my property. I took them to court, and a lot of our claims were dismissed based on the statute of limitations. In particular, the Fair Debt Reporting Act, Real Estate Settlement Act, a lot of different claims were dismissed because of the statute of limitations.
Was Mr. Colsey a party to that litigation?
It was not just myself, Your Honor. It's always been just myself. And so ultimately, I lost that case, and it was ruled in Wells Fargo's favor. From there, it took Wells Fargo an additional, that case ended in 2019. It took them an additional 2 years before they attempted foreclosure again. In that time period, again, Your Honor, I kept trying to get them to accept payments in order to rectify the situation. They refused. So in 2021, they attempted a foreclosure again. I again went before the courts to ask for help in the matter, and the case was transferred without my knowledge from the Superior Court to the District Court. I was never notified of that transfer. From there, the case was ultimately dismissed because I never filed any responses. So in 2022,
was Mr. Colsey a party to that litigation?
He was not, Your Honor.
Okay.
Nope. Mr. Colsey also has never been a party to the mortgage at all. It was under.
No, I understand that, but I'm asking about the lawsuits in particular.
Nope,
Okay.
never. And so in 2021, in September, Wells Fargo claims to have foreclosed on my property. They claim to have sold it to themselves for, I think it was $174,000 or $176,000. We knew about the sale but we did not hear anything else from them until May of 2022, when they brought forth the housing court matter. Again, we tried this time because they had brought both myself and my husband into the matter. We brought forth 93A claims due to, one, not notifying us properly of the sale of the home, not giving me time to try to rectify the home in the default. And ultimately, Judge Kane, through the housing court, dismissed all of our claims. Wells Fargo was granted possession of the property, and I am continuing to fight this because
Is that this case?
it is, yes.
All right, so this case, you were defendants, is that right?
Yes,
They sued for
correct.
possession, and one of your defenses was 93A.
Yes,
Had you brought a 93A claim previously?
I had, yes, Your Honor, but I am under the assumption that 93A claims are not just a one-time deal. If somebody continuously makes errors and does things wrongly, you should be able to bring claims against them.
No, I understand that. I don't know how the law, I don't know. There's something called continuing violation. There's obviously, if there were multiple violations, that would be something as well. But I understand what you're saying.
And also, Your Honor, in this matter, they brought my husband into it. And as my husband was not a prior litigant to any other cases, my husband is due his rights now to have his day in court. And he has 93A claims as well.
Let me ask you this. I'm sure there's more for you to tell me, and I'd like to hear more. Can I ask you about the indigency piece of this?
Correct.
Your husband has not filed a financial statement, or he has now?
He has not officially, as far as the exact document that the court had sent me. At the time that they had asked for my financial information, we had a motion for 60B filed to have the judgment reversed against my husband. I did, in my income, include additional information, which included my husband's employers and my husband's income. So the judge was aware of my husband's employers and his income.
And I'll find that on the financial statement that I have in the appendix here?
You should, Your Honor. If not, I can submit that to the court.
I should have it, I hope. All right. You've still got 4 minutes. I think those are I have one other question. You say that affidavits filed in this case were not based on personal knowledge.
Correct, Your Honor. There was an affidavit filed by Wells Fargo that stated very untrue facts. First fact was that they claimed that I defaulted on the mortgage in January of 2008. I was late on October and November's payments of 2007. I had mailed those payments to option one at the time. They returned those to me in January. But in late January, early February, I had entered a forbearance agreement with option one and had mailed them an additional $10,000, which was credited at the time, which brought my mortgage current to March of 2008. Option one ultimately faulted on the forbearance agreement and broke it, and then put me back into foreclosure again.
Let me ask you this. So this order that I'm reviewing has an appeal bond in it, but it also has use and occupancy payments.
Yes.
Do you object to those? Do you object to the amount of those, or to the very fact of them?
I object to the amount and the fact of them, Your Honor. I have asked continuously through prior litigation and through the housing court matter for Wells Fargo to prove that they actually own and have possession of the original notes, the mortgage. They have never once produced that. And according to multiple case laws of Massachusetts, they are supposed to show that they actually hold the note.
Well, I agree with that, although it may be that that's something that was resolved in one of the earlier pieces of litigation, or could have been resolved but was brought too late or something like that, although I don't understand how that would be.
Your Honor, I had asked for it to be submitted multiple times through multiple motions, and never once did Judge Mastriani in the district court ever rule on that
And
specifically.
you think that even though there is now a judgment of possession, admittedly it's on appeal, there's a judgment of possession, you think that they are not entitled to use and occupancy, even though they have that judgment. Let's stipulate that maybe it's wrong for the reason you just said, but it's in place right now. There is that judgment.
Right.
You think that you're entitled not to pay use and occupancy?
No, Your Honor, if the court rules that I need to pay use and occupancy, I do ask that for the time being, until it is proven that Wells Fargo has any claim to the mortgage note, that money be put into an escrow account.
I see. And the amount that I don't know, what, $1,640 a month or something?
The amount is excessive as well. My original mortgage payments were $1,399 a month, Your Honor. So I asked for, at the bare minimum, those payments to be that at most. If
Well,
not
I mean, okay, that's a little bit different though, because presumably you had some equity in the house.
we do. We currently
Right,
have
so-
$147,000.
So that, right, so the mortgage just doesn't cover the full cost of the house, maybe because it was for only a portion of the value. I also have to say, and I don't know enough about this, they're not mortgage payments. They would be for what the fair market value of the place is now, and that mortgage is 2007, it's 2023. So I'm not sure. I'm not sure that is there any other error in that 1,640, or it's just excessive?
It's excessive, Your Honor. For this area in particular, it's our house is listed as a 4-bedroom, but it's really a 3-bedroom home with 1.5 baths. In this area, you're looking at about $1,300 to $1,400 a month for rent.
I mean, they did submit that sheet that shows fair market values. I understand. I actually, I don't understand what it is. Like, I don't know what that sheet is, but I take it the judge relied on that.
I have evidence, Your Honor, that I was hoping that I would have a chance to submit a reply to their opposition to this today. I have evidence showing the cost of homes in the area and rental properties in the area.
Okay, I don't know that in the first instance I'd be the one to set an amount like that. Your time has expired. I appreciate your argument. I know it's difficult when you're not a lawyer to argue in court.
Thank you.
It can be intimidating, but you've done an excellent job. So thank you
you.
very much. I will hear now from you, Attorney Sprague.
Thank you, Your Honor. This case has been going on for quite some time. The case in 2021 was filed days before the foreclosure was set to happen, and there was a hearing the morning of the foreclosure. So these issues were heard by a Superior Court judge with notice to all parties. All parties attended that hearing on September 2nd, 2021, and the court did find res judicata applied to all.
Was Mr. Colsey a party?
He was not, Your Honor. He couldn't.
So how can there be res judicata as to him?
Because he has no standing to make these claims anyway. He couldn't have been a party to those prior lawsuits because
But
he.
isn't it a valid defense to possession of a resident that you're not the person who holds the note, or that you don't, it's not your house, or you don't get to foreclose on it?
Not when someone is not a party to that mortgage or that note, I believe. He wouldn't have any standing to make those claims.
I think someone can walk into a house where there's an individual residing who isn't a party to the mortgage because their mom owns the house or whatever, and can just evict them without the court having to hear from the resident. I don't know who this person is. They say they hold the mortgage, but it seems like they're just our neighbor across the street.
I would say, I mean, obviously the court can make their own,
Well, I'm asking as a matter of law, whether a resident can bring those kinds of defenses to an action for possession. I would have thought the answer is yes, but I could be wrong about that. You know what I mean? I don't know the answer.
Right. I mean, I've had these issues come up in prior cases where it is a child or someone who's not related, or maybe even a tenant. And I've always argued that, no, they don't have standing to challenge.
What have courts said in response? Do you have a decision?
I don't have a decision off the top of my head. I could provide those. But I mean, that is And I think most of them were in Worcester.
And now let me ask you this. All they have to avoid this bond, if they're indigent, we'll talk about that in a minute, is a non-frivolous argument for appeal.
Right.
Is an argument that res judicata can't be applied against Mr. Colsey non-frivolous? Might be loser. I don't know, but you can't tell me a case that says it is.
Your Honor, I don't believe that it is a non-frivolous. They've made the argument themselves that he shouldn't be in the case at all because he has no standing. He has no attachment to the mortgage.
That's not my question. He's in the case. You need him in the case.
I do, yes.
And I think he's a proper defendant. How would you get possession of the property without him in it? You'd have a person in there.
Right. I mean, maybe if it's not res judicata, it's certainly collateral estoppel. I mean, the issue has been decided by multiple courts that my client.
Non-mutual offensive use of collateral estoppel. I don't know. I mean, you know what I mean? That's.
I do. I understand.
It happens sometimes, but right. I don't know.
I would say this issue has been, this issue preclusion. This issue has been decided multiple times up to the First Circuit.
How can a 93A claim that was brought and that alleges some kind of ongoing 93A violation, how can that have already been litigated in a prior case?
So the issues that they claimed, the 93A claim, were the same issues that were brought up in the two prior cases. And as the lower court had decided, the 2021 case that they filed was not actually dismissed till after the foreclosure happened. So the day of the foreclosure, that morning, it was decided all these issues have been decided, foreclosure goes forward. If there's any issues that could be 93A.
The summary judgment motion that's on appeal now, though, is from the suit for possession.
Right.
And it says raised judicata, but what I'm saying is if they raise a defense to possession, there's a 93A violation. I assume that's a valid defense to possession, although I don't know. How can that have been litigated previously if it says something is going on right now? It's
because the facts of their 93A claim are facts that were already decided. Do we hold the mortgage? Do we hold the notes? Was the foreclosure proper? So that is the basis.
Do you hold the note, and in what piece of litigation was it adjudicated that you do?
It was adjudicated in the first litigation, and it was part of their claims in the second litigation.
Well, you said that it was. I thought the first one was dismissed for statute of limitations.
It wasn't, Your Honor. That's our claim. I can certainly provide all those documents, and the lower court had all those documents, but it wasn't all based on statute of limitations.
So you're saying that in the first action, it was held that whatever you did was adequate to demonstrate actual possession of the ink signed note.
That we had, yes, that we were able to foreclose. And in Massachusetts, in order to foreclose, you have to be the mortgagee and the note holder.
Yes,
so that was the decision, yes. And that was the decision in 2021, where that morning hearing allowed us to go forward.
I guess I would say this, although obviously it's ordinarily the appellant's burden to create a record. I have a hard time figuring out what's res judicata without seeing, those earlier decisions, and frankly, the complaint and answer in this case. If you could submit those, that would be helpful to me. If you assume you have copies of them.
Yeah, they're all exhibits to my motion for summary judgment, my motion to dismiss. Because they're
in the record here, but not in the appendix. So that's fine. So I can look at them. So if you can get copies to our clerk, however you submit things, that would be helpful to me. Let's talk about. Let's talk about indigency. This confuses me. Two people share a house. Let's say they're not a married couple. They're just two college students. They share a house. One of them is indigent and one of them isn't. Not that I'm saying Mr. Colsey isn't, but maybe it hasn't been demonstrated. So, all right. One of them is and one of them isn't. Surely the right to appeal of the indigent one that is protected by not having to file an appeal bond if you're indigent and have a non-frivolous, surely that right can't be extinguished because their roommate is rich, right?
Well, I would say both the roommates owe the rent. And if this were a regular roommate situation, usually if one doesn't pay the
It's
rent at
not
all, the other owes
it's not a
100%.
roommate situation, it's a suit for possession situation.
Right. I'm just saying that in either case, when use and occupancy is owed or rent is owed, whatever is owed, if one party can't or doesn't pay, they pay zero, the other party owes 100%.
That may be fine, but shouldn't the appeal bond, if there were non-frivolous, shouldn't it be waived with respect to the one who owes zero?
I would say no. I mean, that would basically
But how can you
every
do
married
that?
couple where one person stays home and one doesn't, one's going to look indigent and one's not.
Well, looking indigent and being indigent are two different things,
Yeah.
right?
Yeah, I think it could be, you can make the paperwork look like one party was indigent in quite a lot of
You
circumstances.
could, but that's why we have courts to review those documents so that people don't falsely demonstrate indigency. I'm just having a hard time sorting out how it can matter once one of them is found indigent. I'm not saying you might not be entitled to an appeal bond from Mr. Colsey and his appeal might be dismissed. But if you have, and of course, this assumes that there's a non-frivolous argument on appeal. But I'm just having a hard time seeing how, all right, so the two roommates are one's poor and one's rich. And the poor one says, well, I want to do this appeal. And the rich one says, not me. I don't care if it's dismissed. I'm not paying that bond.
And I think that
How
the
can
point
we
of
have
the
a private
bond,
party that, yeah.
yeah, the point of the bond is to also protect my client who is paying the taxes, who's paying the insurance. And I am fine with the bond being paid into the court into an escrow account. And if they win, they get their money back.
The use and
I'm fine with that.
occupancy.
Yes, I'm fine with that. I know the court order says it should be paid to my client, but typically my client doesn't even like to accept them. They would rather have them paid into the court just in case. So I have no problem with that. But the point of the appeal bond is also to protect my client who's still making these payments. And if there are people living there,
And am I correct that your reading of section 5, I think this is right, but I don't, you know what I mean? I need to look into this a little more. Am I correct that your position is, even if indigent, even if non-frivolous ground for appeal, use and occupancy can and must be ordered to cover costs during that time? Is that right?
Yes, and I think there was some confusion about this several years ago, whether you could do both or waive both. But I think it's been, decided with the Alton King case that even if the bond is waived, then the use and occupancy.
I get it. Okay.
And Your Honor, I would also mention that at the hearing for the appeal bond and for the motion to for the judgment to be reconsidered, the court was very explicit that Mr. Colsey had to fill out that form also.
Well, sure, but I just don't know if that's right.
Right.
I mean, I get that, but there's something, I have to look into this more. There's something odd about the happenstance that your co-defendant isn't indigent, having some control over your rights. But
So I do think, this is not a roommate situation. They are.
Well, I understand that, but I also don't know, again, now we're way, how do we figure out indigency of married people? What assets are you supposed to look at? I don't know anything about that. Is there any more you want to tell me?
Your Honor, there's no evidence to the contrary of, what the judge found as the fair market value. We based it on the HUD estimates for this area, but there was no evidence put in to contradict that whatsoever. If Ms. Colsey is fine with $1,400 being the use and occupancy amount, we certainly wouldn't want further litigation over if it's $1,600 or $1,400. But
I'm not sure I follow what you're saying. You're saying that you'll accept $1,399 as use and occupancy?
If Your Honor wants some kind of, if you would want a separate hearing or more evidence, we wouldn't want to do that. We do think $1,640 is the correct amount, and it is also the amount if you look at what their mortgage was and the increase in taxes.
What was the procedure used in setting this? Was there an in-person hearing? Was there an opposition?
Yes. So the judge had ordered that any motions regarding the appeal bond be filed by March, I think, 22nd or 24th. And the Colseys didn't file anything. We filed a motion to set appeal bond. They opposed it. And in their opposition, the judge basically treated that as if it were their motion to waive appeal bond. But there was no evidence presented in that motion regarding what the fair market use and value, rental value was. The only arguments in there was the fact that they didn't think Mr. Colsey should be in the case, and they thought they had a good defense. But there was no evidence or argument regarding what the bond should actually be.
Okay, can I also ask you, I've asked you to submit a few things. I'm not sure if we have at least one financial statement in the appendix that we have, but Ms. Colsey referred to one that also references something about Mr. Colsey's income. Do you know what financial statement that is?
No, Your Honor, it was held that my client wouldn't be privy to that information. They wanted to keep that private. So I haven't seen the financial statement at all.
You haven't seen any financial statement. That is, this was all looked at in camera by the judge.
Yes.
in making the determination of indigency. All right, perfect. Do you have any? All right. I asked if you had anything else to tell me, so I guess I've heard. What else do you have to tell me? Thank you both very much. That concludes our hearing. I will endeavor to get some order out quickly, and the case is submitted.